or B1. It says opt out. In general, a financial institution may not disclose your non-public personal information or non-affiliated third party unless. So when it has the word unless, that means that it's conditional. So what are those conditions? Well, before I get to that, let me break down this legalese right here. Well, a financial institution, we know who that is. Let's just go. It could be Capital One, American Express, Finger Hut, whatever, whoever that is. And not disclose your non-public personal information. Well, what is that? Your non-public personal information is the account number, the balances, your social, your address. That information is not public information. A non-affiliated third party. Well, who is a non-affiliated third party? Well, TransUnion, Equifax, Experian, any of the consumer reporting agencies, a lawyer's office, third-party debt collector. They can't share that information unless, okay? Excuse me, what are the two? A, such financial institution clearly and conspicuously discloses to the consumer in writing on electronic form or other form permitted in regulations prescribed in Section 6804 of this title, that such information not will be disclosed, right? Not will be disclosed, but may be disclosed to such third party. Not will be, but may be. And that's the key there. So not that they will, but that they may be. But look at B. Let me blow B up so you see this. The second, so the first part is they must contact you to let you know that they may put it on, or they may disclose it to a third party. Look at B. The consumer is given an opportunity before the time such information is initially disclosed to direct that such information not be disclosed to such third party, right? So the consumer is given the opportunity before the time that such information is initially disclosed to direct that such information not be disclosed to such third party. Also, the consumer is given an explanation on how the consumer can exercise that non-disclosure option. Number one, if they don't contact you, they're in direct violation of the law. Why? Because they must contact you before they put that negative item on your consumer report. And in order to put it on there, right, you have to give them permissible purpose. You have to say, yes, it's okay. Remember, we looked at permissible purpose, 15 U.S.C. 1681B, and it says in written instruction from the consumer to who it relates. So if you did not give them permissible purpose to put that, now it goes for good and bad. It doesn't go for just negative things. Before they put anything on your consumer report, you must first give permissible purpose. So that's why they don't contact you. They don't contact you, number one, because they know what you would say. And number two, they don't contact you because they know that you don't know the law. They know that you're not going to say anything about it. You're not going to say, oh, you guys violated my rights under 15 U.S.C. 6802, obligation with the respect of disclosure of personal information. No, because the average person in America, you don't even know consumer law to that extent. But this is why, and I told you earlier that I was going to prove to you that they're violating your rights each and every day. I just proved it. Because they don't contact you, but they're supposed to contact. Also, the same thing I showed you with 15 U.S.C. 1681A, when we went down to Section 2, it says it right there, right? That transactions or experiences are to be excluded from your consumer report. So that means that late payments, the balances, isn't a charge off a transaction? Yeah. Isn't a repo a transaction? Sure is. What about a bankruptcy? What about foreclosures? They're all transactions. You said, well, okay, Mr. Scott, if that's the case, then nothing's supposed to be in my report. No, that's not true. Only the things that you want on there. Remember, we read what it says that the consumer reporting agencies must be cognizant of the consumer's right to privacy. That's why I can say what I want on my consumer report, because I have the right to privacy. No one needs to know that all of these things are on my consumer report. No one needs to know that.
I'll explain to you guys how this information was found out. Primarily, paying checks, Marvin never uses cash or credit card to pay for anything at the courthouse. He always uses a check. And once a check is negotiated or processed, on the back of the check it has all the routing numbers, okay? The routing numbers and usually a phone number, so you can call and find out who it is. Otherwise, you can use something called the Public Records Act. I don't care what state you're in, everyone has a Public Records Act. And in some cases, if you're dealing on a federal level, you can do it under Freedom of Information. Now, under Public Records Act requests, in California and Hawaii and other states, I'm sure it's across the board it's the same. If they fail to answer, it's a $1,000 fine. So it's all about how you put it on a piece of paper. But the law is created for your benefit in the event, at least we would like to think, it's created for our benefit, that there is a particular check and balance, but they tuck it away or they hide it away in codes. Well, what are codes? By definition, they're something that's used to hide something. The military uses codes all the time to hide their communications, etc. So the money that is paid to the Judges Association is used to pay off anonymous bonds. Okay, the anonymous bonds are issued through Merrill Lynch and other associations, but Merrill Lynch is the primary bad guy. And we have paperwork that demonstrates this. Marvin got a judge thrown in jail, and prosecuting attorneys, and there's more on the way. Because you ever heard of judicial immunity? Well, guess what? You don't sue the judge, you sue his association. Or you find the evidence of the wrongdoing through Public Records Act requests, so you trace the money on the check, and then you present the data to the grand jury, and they got investigated. And then they got a problem. So, as a result, Credit Suisse and Bank of America are the primary underwriters on those bonds. And a company by the name of DTC, it's called Department of Trust Corporation, controls the bonds. But guess what? DTC is ran by the Federal Reserve board members. Okay? If you take a look at who's on the payroll, it's all a complex matrix. And how do they want you to pay? You're not using gold or silver to pay at the courts. I tried to pay them. They don't take the stuff. I tried to use all kinds of stuff at the courts, guys. But they want that Federal Reserve note product, the private product that's set up under a sham situation, 1913, set up the same time as the IRS, 1913, and there's some other agencies which I won't mention that were set up in 1913 too, which is a little kooky. I'll tell you later. So I like to call these things Anani bonds. The interest on the Anani bonds is paid through the court fees, fines, and restitution, and along with forfeitures. So when you get convicted, in a traffic ticket matter, not only do you pay, let's say it's $100. Usually there's a statutory limit on traffic tickets. But what do they do to create more revenue? They give you what's called a penalty assessment. And last time I checked, that I was in court, was 170% penalty assessment. So you pay an additional 170% on the top of the $500 fine for traveling down the highway, on the high seas, as they would call it, etc. So the credit rating of the anonymous bonds that are issued by Merrill Lynch in association with Bank of America and Depository Trust Corporation, in association with the Federal Reserve, who is in association with the IRS, based out of Puerto Rico, is all based. The credit rating's performance is based on or determined by the courts or the banking business ability to arrest, prosecute, and convict, or with respect to civil matters, litigate. So what we have here is a perpetual meat grinder that's feeding off itself. It's infinite because it's a system that is endlessly perpetuating itself. And the more you use Federal Reserve notes, the more there's national debt, the more money that needs to be paid to the IRS. But let's take a further look at what the bonds are for. The bonds, the finance payment to contractors for the building of more courthouses. Okay, so what I'm saying is it's perpetual. They do more than courthouses, but that's the principal amount. Well, they're probably all in concert. Not even probably. I mean, the buildings look the same even. So, but they also build things as post offices. Now, interestingly, in the city of Van Nuys, the Van Nuys courthouse, Marvin Breyer found out that the entire courthouse, was bought for $5 by a judge. And Marvin, by the way, has disqualified basically the entire bench. There's no judge that can't hear Marvin's case because what he does is he uses Public Records Act requests, FOIA, and he also goes down to the local library and pulls the judge's statement of economic interest. Once a judge becomes a judge, they have to give their entire profile, where the money's going, and they might have some stuff offshore and et cetera that you might not be able to find. But for the most part, the way he creams these guys is he finds out, okay, who's this guy ruled on? He'll pull their whole case history, how many cases he's ruled on, and he'll see, well, he ruled on a case dealing with McDonald's, and he owns stock in McDonald's. So he reverses entire court cases or kicks judges off because there's a conflict of interest. So it's all based on money, conflict of interest. And he also finds out through Freedom of Information, or namely Public Records Act. In one instance, he found out that the judge had a brain tumor. But he's still making all these decisions off the bench. He walks right into court, especially when he's powered up about their conflicts of interest or he's tracked the check. What he does is he'll buy like one page of the docket, costs $1. The next day he'll go back and buy another page of the docket. And what'll happen is none of the checks that he's using to reflect pages of the docket being bought are not showing up when he has all the invoices reflecting that he's purchased the stuff. So, and then he tracks the money, finds out that it's going to the Judges Association, etc., and he generates more conflicts of interest. And what Marvin will do is he'll go into someone else's court case. Say your court case was litigated on like 6 months ago, and you already got the book thrown at you. He'll go in and buy a page of your docket and track where the money goes, and finds out that it went to the Judges Association, and he'll file a complaint against the judge, and he can get your whole case reversed based on conflict of interest. The judge is going to jail, and your case is reversed non-pro-tunk, as if it never happened. So. But the principle that the reason why I'm trying to present this information, because these guys have inherent weaknesses. And our system, and I believe in the concept of law as agreement between the parties based on natural law principles. Whether you look at the Bible or any particular belief system, there's common natural law principles that if most people never violate, we never have a particular problem. So in any regards, you hit them where it hurts, and it's the money. Because anytime these guys are fooling with money, they have a bad habit. And it's usually as a result of their misappropriation of funds. And you guys want proof? Here's a sample of the couple of checks that were cut from the Judges Association. This one is only $71.60, but we have others that range from several thousands. And but it doesn't take $571. But we have some that got a couple extra zeros on there. But the whole point is, all it takes is 1 cent to be misappropriated for the guy to go to jail. Yeah, my stepmother used to work for a judge in a courthouse, and they couldn't even make a photocopy of something for anything other than what was required for their particular office. Otherwise, it was considered a misappropriation of funds, and if it was a felony. So 1 cent is all you need. So this is an example of Marvin's slush funds. If you guys do a Google search, you'll find endless articles about Marvin and what he's been able to do. This is the end of the basic essence of my presentation, but I'm going to talk to you guys more in detail about how to do Public Records Act requests. But in relation to the PowerPoint, as in the words of Jordan Maxwell, you better go back and do your homework.
Lawful money. Well, we just established legal tender is currency, is paper currency, and we take something to go lawful money is gold and silver. 1 ounce of gold, 1 ounce of silver. That's lawful money. This is legal tender. But now let's look at our currency here for a moment. Not only is it design offensive as paper currency, but you'll notice that this has different colored seals on it. The red seal, red serial numbers. Blue seal. Oh, it's blue. Let's look at that one for a moment. Let's just say down here, silver certificate. $1 payable to the bearer on demand. That's $1 right there. $1 is 371 1/4 grains of silver. That's the dollar. This is not a dollar. This is a $1 silver certificate. Redeemable originally in the banks for $1 silver. Now we have, of course these are old and you can see that. No serial is a 1 because that's what it is, 1. Here's a 5, that's a 5. But over here we got what's that, a seal? And here's a seal. Let's talk about this currency here for a moment. A, that's the corporate seal of the Federal Reserve of Boston, Mass. If it was Federal Reserve Bank of New York, it would be a B. Philadelphia, C, Cleveland, Ohio, a D, and through the alphabet of the 12 Federal Reserve Banks. This is a piece of currency owned by the Federal Reserve Bank of Boston, who charges us rent to use private currency. This is private currency. This is private currency. This is public currency. Let's talk about public and private. Private is owned by the banks, and we have to pay to use their private currency. But we didn't have to pay the banks a penny to use the silver certificate, and we didn't have to pay the banks to pay. Now I want you to close up onto this because that says United States note. So we have private currency, public currency, but the public currency doesn't cost us anything to use because it was printed by our government and spent into circulation. Now I don't know if you can do a close-up on that, but you'll see the date, 1963. In 1963, what happened on November 11th of 1963? Our president was assassinated. And many people believe, and I'm inclined to go along with their thoughts, that the reason President Kennedy was assassinated was because he introduced the United States note, which was backed by silver, to eliminate the national debt that we're paying to the bankers for using their private currency. This is private currency. The bankers only pay about 6 cents for this. So there's a only pay about 6 cents for this. So there's a how much would you like to buy a $20 bill for 6 cents? That's what the banks pay. Even that's all they pay for a $100 bill. So what are we talking about? Federal Reserve Accounting Unit denominations. That's a denomination. This is a $20 denomination, a $1 denomination. Well, what does Federal Reserve Accounting Unit denomination really spell? What's the acronym? Fraud. F-R-A-U-D. That's a fraud. These are frauds. So we have lawful money, gold and silver, and legal tender. But this is private, and this is public. I think Mr. Kennedy the first things that Lyndon Baines Johnson did was to remove these from circulation and permit the banks to extort the wealth that they have from we the people. Banks do not produce anything except the first things that Lyndon Baines Johnson did was to remove these from circulation and permit the banks to extort the wealth that they have from we the people. Banks do not produce anything except chaos and confusion. End of my report. Very good. Excellent.
I keep telling people the agent is never liable for the principal unless the agent doesn't do their duty. And you still got some of these people that do not want to go look nothing up. They say the agent is always liable. That's because you don't understand law of agency. Right here. Is an agent liable on a contract made on behalf of a principal? An agent is not a party to, nor individually liable on a contract that he enters on behalf of his principal. It is the principal who enters into the contract. Under Connecticut law, a bunch of them under Connecticut law. An agent acting legitimately within the scope of his authority cannot be held liable under Connecticut law for interfering with or inducing his principal to breach a contract between his principal and a third party. Because to hold him liable would be, in effect, to hold the corporation liable in tort for breaching its own contract. In other words, the corporation would be the principal. An agent could not be held liable for the principal's breach of contract. See, an agent executing a contract on behalf of a disclosed principal is not liable for a breach of the contract unless it clearly appears that he or she intended to bind himself or herself personally. There must be clear and explicit evidence of the agent's intention to substitute or superadd his or her personal liability for or to that of his or her principal. So again, you keep saying the agent's liable. Everything I keep showing says when the agent does their duty, they're not liable. It's the principal that's liable. The liability comes to the agent when the agent doesn't do their job.
Hey everybody, hope you're having a good Wednesday. So I wanted to take a look here about this whole October 4th thing, and I'm currently looking at the FEMA and FCC plan nationwide emergency alert test for October 4th document on the FEMA website.